Hi, everybody. It's Harvard lawyer Lee. Well, the moment we've all been waiting for is finally here. Since the time of the trial, we have been wondering, what will Amber argue on appeal? What are the grounds she's going to actually use for her appeal? And it turns out we were asking the wrong question. The question we should have been asking was, what grounds won't she be using on her appeal? Because, wow, what a doozy of a brief. It has 17 different grounds, 17 different arguments about what the court should be doing to overturn the verdict against Amber Heard. It's massive. It's 55 pages just of the actual brief and more if you count the table of contents and the table of authorities. It was filed by Amber's new appellate lawyers. Ben Rotenborn also signed on. If you've ever heard the joke about anytime you've got two lawyers, you're sure to have at least four opinions, it's kind of true, because what happens when you do a brief with a legal team is everybody has some argument that they think is really important. People try to pare that down. Whoever's in charge of the brief will say, yeah, we don't have enough room to cover all of these different arguments. But someone on the team will say, yeah, but we were right. We were right on that. We should have won. So reluctantly, that will get added back in. And over time, when you've got a legal team, all of the arguments get added back in. What you have to do to figure out which are the most important arguments is do two things. First of all, you look for what is argued first. That has some value here. However, they also divided it by what the result would be. So that's not quite as useful here. We'll talk about some of those as we go through the brief. And then the second thing you look for is which ones did they spend the most time on? Because you have a very limited amount of words, depends on the court, words or pages that you can use in an appellate brief. And covering 17 arguments is extremely difficult within the limited confines. So what will happen is some arguments will get put in, but really short versions. So if you have one argument that the team devoted 7 pages of its 55 to, and one argument where it only got 3/4 of a page, you can bet that the one that got the most room was also the one that the team thought was most important. So that's another way you can tell. I am going to today do a super fast run through the 17 arguments, just so you know what the lay of the land is. And I base that both on where they are in the brief, but also on how many pages they devoted to it, or just how important I thought it was. And while I'm thinking about it, please be sure to like the video, subscribe. I would love to see you back, and put your questions in the comments below. I'd like to know a couple of things. The first is, if there's an area as we go through this that you find particularly interesting, I'm going to say several times, this is an area that's a lot bigger than what I'm going to talk about in kind of a quick video. So if there's something where you see an area, hear about an area, and you really want to know more, put that in the comments. Also, if you have questions, I'm probably going to do a live stream answering questions. So write down anything that occurs to you as we go through, so I'll know what it is that really interests you. And now, let's go to the brief. There are 3 basic categories that Amber divides her brief into. The first category is arguments that would get the whole case dismissed. That means it's gone forever. Amber doesn't have to deal with it. Now, Johnny might, at one point she argues, go out to California and file the case, but this case, over and done, nothing left. And Amber has 4 different arguments that fall into that category. That's obviously her number one best, because if the case is gone forever, that's what she'd like. Now, she also has 2 arguments that would set aside the verdict. That means that even though she lost the verdict, that would be gone and she would now win the case. All the rest of the arguments fall into the category of arguments that would buy her a new trial. She would still have to go through another trial, at least most likely. So from her perspective, that's not as desirable. Truthfully, nobody really wants a new trial. You've got Johnny Depp, who doesn't want a new trial. The court has already spent an inordinate amount of time. We could clearly see from the way she handled the post-trial motion, she's done. She would like to be over with this case. And the appellate court will be reluctant to send the case back for a new trial. But that's where the majority of her arguments, 11 of them lie. So category one, these are arguments that would get the whole case dismissed. So the first argument that Amber makes, first meaning probably it's pretty important to her and she spends a lot of pages on it. So this is important for both reasons, is something called forum non-conveniens. That sounds very complicated, I know. Here's what it means. Forum means the place where your case is filed. Not, you can figure that one out. Conveniens means convenient. So all this argument means is filing the case in Fairfax, Virginia was inconvenient. It wasn't a good place to have the case. Her arguments are that the witnesses weren't in Fairfax County. The witnesses were from California, and the case should have been filed in California where the incidents occurred. But there are a couple of problems for Amber with this. The first is California really isn't better for her either, because these incidents happened all over the world. You think of the Australia incident, you think of the incident on the Caribbean island, you think of incidents in Europe. And in fact, there were witnesses from all of those places who came to trial or testified by videotape. You think of Kate Moss, who testified from the UK. So California isn't particularly better in this case. This probably merits its own video. If that interests you, be sure to stick that in the comments below. The second problem Amber has with this is that forum non-conveniens is discretionary. What that means is the court can do whatever it wants. It can decide, okay, yes, I think it's inconvenient, I'll dismiss it. Or the court could easily decide, I don't think it's inconvenient, we're going to keep it here. And when I say the court, I mean the trial court. It would never be reversed on appeal. The way Amber tries to do an end run around that is she says because the court ruled a certain way on jurisdiction, it never even considered whether or not it was inconvenient. And the court should have considered that. I will get Johnny's response. Often a court will decide in the alternative to a sort of problem. Often a court will say, I'm going to decide on jurisdiction. And just in case anybody ever asks, I also don't think it would be inconvenient to have it here. But I don't know what the case was. The second argument that Amber makes was that what she said was an expression of opinion and protected under the First Amendment grounds. I was frankly very surprised that Amber did not devote more of her brief to this. She literally gave it like a page, less than a page, really, when you think about it, even counting the title, it's less than a page. This was a primary argument that she had at trial, that she should have been allowed to say the things that she said. They were protected under the First Amendment, and Johnny Depp should not have been able to sue her. So I was surprised it did not get more attention. I don't know whether she thought she couldn't win in Virginia or whether she just felt like it didn't need much. The argument was really clear. The third thing that Amber argued was that there was no defamatory implication. What she's arguing here is that the op-ed that she was found liable for doesn't mention Johnny Depp, just, according to her, advocates for changes to laws and rules and social norms. Johnny Depp says, well, it referred specifically to an incident 2 years ago. It says 2 years ago, I became a public figure representing domestic abuse. And everybody knows what that means. 2 years ago is when we got divorced and you filed a temporary restraining order accusing me of abuse. Everybody knows that. Amber then argues, look, if I'm not allowed to talk about the effects of what happened when I filed for that temporary restraining order, then you're going to prevent all people from talking about, speaking out about abuse. She uses a comparison with this sentence. She says, 4 years ago, Christine Blasey Ford became a public figure representing sexual assault. You may remember when Brett Kavanaugh was being considered for the Supreme Court, Christine Blasey Ford accused him of SV from 34 years earlier when they were teenagers. That was controversial. That's unusual to put anything remotely controversial, particularly something that's not really necessary, in an appellate brief. For Amber Heard, I think part of the problem with this argument is going to be that Amber argues Johnny Depp was simply reviving the petition for a temporary restraining order from back in 2016. But that's really not a fair characterization of what Johnny Depp was doing. When Johnny Depp sued, he sued over 3 brand new statements that were made in the op-ed. Those brand new statements were in painstaking detail given to the jury, and the jury had to make finding after finding after finding about each of those 3 statements. So I don't think this is really just arguing the temporary restraining order over again will work, because the judge was so specific with the jury. The fourth argument is that Amber Heard argues that Judge Ascarati should have applied the ruling in the UK case. In the UK, Johnny Depp sued the Sun for statements that the Sun made about him, including that he was a wife beater. Johnny Depp lost that case. Amber argues the findings in that case should have been binding on him. I strongly disagree with that argument. Strong. It was a different case. It was a different country. SV was in the Virginia case and not in the UK case. It wasn't even the same parties, because the case in the UK was Johnny Depp versus the Sun. The case in the United States was Johnny Depp versus Amber Heard. Also, I'd like to point out again, there was no jury in that case. This also probably deserves its own video. This particular argument, I think, is especially dangerous, and I feel strongly about it. So if you'd be interested in hearing more about this particular issue, let me know that in the comments below. Just write UK ruling, so I'll know that that's of interest to you. Now, category 2, remember I mentioned category 1 was all of the things, and there were four arguments that would get the case dismissed, like doesn't exist. Category 2 is arguments that would set aside the verdict, and they both relate to actual malice. In defamation of a public figure, the Supreme Court has said it's not enough to just prove that it was a false statement. You have to prove that the false statement was made knowingly with actual malice. They spend substantial time talking about the actual malice issue. Amber argues first that she did not intend to accuse Johnny Depp of DV or anything in the op-ed. And in fact, she took his name out. She had lawyers look at it, and lawyers thought the way it was worded was just fine. That's her first argument under actual malice. Her second argument is that she really did believe he abused her. In other words, even if she was wrong, even if she was objectively incorrect, he did not abuse her, she thought he did. So in legal terms, she's saying Johnny Depp never proved she made these statements without believing they were true, because she personally believed they were true. Now, category 3 is arguments that would get her a new trial on at least some issues. The first one, and substantial space is devoted to this, is Amber's reports of abuse to medical providers. Judge Ascarati excluded those because she said they were hearsay. There is a hearsay exception for statements made to a medical provider in order to get a medical diagnosis or treatment. And the idea behind that is, if you're going to go to a doctor to get diagnosis, you have a whole lot of incentive to tell the truth, because it's your body, it's your health, and you don't want to get bad medical treatment. But you have to actually be getting a medical diagnosis or treatment. If you're not trying to get a medical diagnosis or treatment, you don't have that same incentive to tell the truth. And the judge said in this case, Amber Heard was not trying to seek medical diagnosis or treatment, so I'm not going to let these statements to medical providers in. Amber also argues there's an exception for proving state of mind. You can prove that I thought I was being abused. Judge Ascarati considered both of these and dismissed them, and it's probably pretty unlikely that the appellate court will overrule her, but they spent 7 pages. They feel strongly about this. This is one of their key arguments. Now, the eighth issue that Amber Heard addresses is Stephen Deuter's, Johnny Depp's personal assistant, sent a text to Amber Heard saying, "When I told Depp he kicked you, he cried." The court didn't allow that in, and Amber argues that should be deemed an admission by Johnny Depp because Deuter's worked for him, and that should be considered something Johnny Depp said that fully admitted what he did to me. The ninth argument that Amber Heard makes is that the jury should have been told what the result of the UK case was. The jury did find out that there was a UK case, but the judge kept the parties from talking about what the result was of the case. Amber Heard argues that the jury was left with the impression that Depp won, that the outcome of it was favorable to Johnny Depp. So Amber argues that the jury should have been told about the result in the UK case. The 10th argument is about a very specific question that Amber's team asked Johnny Depp. Johnny Depp was asked the statement that Amber made that I became a public figure representing domestic abuse. Was that true? And Johnny Depp was not allowed to answer that. His team objected on the grounds that it called for a legal conclusion. And someone who isn't a lawyer isn't asked to give a legal conclusion because how would they know? I doubt that this rises to the level of reversible error, meaning something big enough that an appellate court is going to reach down and overturn the entire case because of it. That's my guess about this, and they don't spend a ton of time on it, so I would assume they think the same thing. Now, the next two arguments are, I think, of great interest. The first one is the charitable donations. You may remember, of course, that Amber Heard said that she had donated funds to charity that she got in her divorce from Johnny Depp. And at trial, Camille Vasquez spent some serious back and forth time with Amber Heard. And finally, what came out was, in fact, Amber Heard had not donated that money. She had pledged it, but never donated it. That was important for Amber's credibility. And Amber says that should never have been allowed in. That whole discussion about my charitable donation should not have been allowed in. The problem with that is twofold. First of all, that Amber's credibility was 100% on the line. And secondly, that she opened the door with some of her comments about not wanting money from Johnny Depp and the divorce not being about money. So both of those things, I think, will hurt her with that particular argument. The next argument that she brings up is that the judge admitted evidence of the Tasya van Ree incident. You may remember it was a situation at the Seattle airport where Amber Heard was aggressive toward her domestic partner, Tasya. The problems are, first, that frankly, very, very little came in about that incident. It was extremely short. When you're talking about a 6-week case, this was very minor. And the second thing is that really relates to whether or not Amber abused Johnny, which was not Johnny's case. So the primary problem with this argument is that it doesn't really relate to the main part of the case that she lost. It relates to the part of the case that is not as important for her and that she doesn't want reversed, which is where she won the $2 million. I got to the end and realized, wait, where's number 13? So with no further ado, number 13. Amber argued that the jury was encouraged to award damages that had nothing to do with the op-ed, and she wanted to do a few things to remedy that, to get rid of the problem. The first was the Sun article. We've already talked about that. The other was the UK judgment. We've talked about that. And the third thing was she wanted to introduce articles that were just in general suggesting that Johnny Depp had a bad reputation. For example, she actually named a particular article that said Johnny Depp allegedly showed up drunk to movie premiere. I cannot imagine the scenario where the court allows in articles like that with no foundation and no evidence, but that's what she's arguing, is that the jury should have been able to see newspapers like that, headlines like that, so that they would know Johnny Depp already had a bad reputation and his problems were not related to the op-ed. The 14th argument is no surprise whatsoever. It's that Amber Heard did not write the headline. We heard about that a lot during the trial. that the headline was, "I spoke up against SV and faced our culture's wrath. That has to change." That was the headline of the online version of the Washington Post op-ed that Amber authored. Amber said, "I never knew that was going to be on there. The Washington Post added that. I didn't write it. I didn't have any control over it being added." The problem, and what the judge found, is that Amber Heard retweeted it with comments adopting it. And as a result, she was responsible for it, even if that wasn't something she initially wanted or initially wrote. This was argued exhaustively to Judge Askarati. If the appellate court wants to reverse on this, it has a full record on which to do so. But it just is what it is. They have a difference of opinion on that, and we will see what the appellate court does with that. I think the fact that she adopted it is likely to be, under Virginia law, enough to make her liable for it. We will see. The 15th argument related to a specific jury instruction, not one that was given, but one that they said should have been given. Amber says the jury should have been told that it had to find that I, quote, either intended to communicate the defamatory implication or knew of it and was reckless in regard to it. So she's saying the jury should have been told I intended to communicate that information, or I knew about it and I was reckless about it. I doubt seriously that the court is going to reverse on that. If they agree with her on that, they might say that as a reverse on another ground. But I doubt that the failure to give this one instruction is going to, in and of itself, torpedo the entire case. The 16th argument is that the jury verdicts are inconsistent. I addressed this in full fashion after the initial verdict because there were articles, and Amber said, and her attorney said, you can't have Johnny win and have Amber win. Absolutely you can. Absolutely you can. These were two different charges. There is no reason why both of them can't win. They were different. Two people clearly can defame each other. This may deserve its own video too. Definitely possible for Amber to abuse Johnny and for Johnny to abuse Amber, and it's possible for Amber to defame Johnny and for Johnny to defame Amber. There's nothing inherently inconsistent about those things. It's possible for both to be true. You'll also remember that the one statement that Amber won on came from Adam Waldman, and it was much broader. It talked about Amber Heard and her friends having cleaned up the place, having called the police. It involved a lot of details about which there was simply no evidence at trial. So the fact that the jury thought there wasn't proof that that was true does not mean that all of the things that Amber said against Johnny were not defamation. The 17th argument made by Amber Heard in her appeal is that the damages award was excessive. It just wasn't fair because it was so large. She argues the damages were supposed to be limited to the period of time between when the op-ed came out, December 18th, 2018, and the time when the UK judgment was issued on November 2nd, 2020. Amber argues that her op-ed is not what damaged Johnny Depp's reputation, that he didn't have a contract for Pirate 6 on the table that he lost because of the op-ed. He never had one. That this entire suit is really all about the restraining order in 2016, which Johnny Depp should have opposed back in 2016, not now, not in this case in Fairfax County, Virginia. They quote some unfortunate wording from Johnny Depp's attorney, Camille Vasquez, at trial, and they quote some unfortunate wording from Johnny Depp's opening testimony talking about 6 years ago. But the experts had very limited time frames. They talked about the actual evidence that came in about what had been lost was limited to that time frame. So those are the 17 arguments. Let me know in the comments below if there's some that are particularly interesting to you. You'd be interested in learning more about them or hearing more about it. We should be getting Johnny's response to Amber's appeal soon. That's how appeals work. And in this case, there will be 6 briefs because Amber had an appeal and Johnny had an appeal, and Amber has a response and Johnny has a response, and then Johnny has a reply and Amber has a reply. So total is 6 briefs. We will be hearing more both from Johnny and from Amber on these 17 arguments. The reply brief that Amber has is even shorter than her original brief, so I doubt she will address all the issues. It will be even more evidence of what she thinks is most important. Be sure to like and subscribe, and I'll see you in the next video.